Our next speaker is Mr. Alan Kemp-Gee. And as most of you know, he is one of the very best known of the bankruptcy experts, of the receivers. He is, of course, a partner with Peat Marwick. He is president and director of Peat Marwick Limited. He is chairman also of their National Insolvency Practice Committee. He was made a chartered accountant in 1962 and joined the Peat Marwick firm in 1971 as managing partner of the firm's National Insolvency Practice. He's been involved directly or indirectly during the past 10 years in over 500 bankruptcy situations covering every type of corporation and situation that you can imagine. He's been past president of the Ontario Association of Trustees in Bankruptcy. He is one of the founding directors of the Canadian Insolvency Association, past chairman of the Bankruptcy Committee of the Institute of Chartered Accountants of Ontario. I do point out a printing mistake in the program where it talks about the topic, and as you may have noticed, it says insolvency practice, a receiver's view, insolvency in 2 words. Should have been 1, except that possibly the printer realized that it is very much a solvency situation for Mr. Kemp-Gee at least, and I give you Mr. Kemp-Gee now.
Thank you. The last time I checked, anyway, my practice was solvent. But, as the chairman has indicated, my topic today is insolvency in practice, a receiver's view. This series of the March special lectures is devoted to corporate law in the 80s. Over the past couple of days, you've heard about many different aspects of corporate law. All of the previous presentations have quite reasonably assumed that the company is, if not flourishing, at least a going concern. Today, I forgot this thing. Today, many companies are not flourishing. The number of corporate failures is increasing. In the experience of most business executives, the current inflation, interest, and unemployment rates are at historically high levels. It is generally conceded that the current recession will be the deepest and most enduring since World War II. Our domestic economy is suffering from severe financial problems. Corporate profits are crumbling, and liquidity is deteriorating. Economic difficulties in the Maritimes generally, and in Ontario and Quebec, are surfacing at an accelerating rate. And many economic sectors in the other provinces are suffering in one way or another. Perhaps the outstanding feature in our commercial environment over the last 10 years has been the sheer volume of business failures, both in terms of the number of companies going under and their size. The survival of companies which, just a few years ago, appeared to be the financial equivalents of the Rock of Gibraltar is now openly speculated about. Who, a few years ago, would have questioned the survival prospects of International Harvester, Chrysler, Ford, or AMP? As conditions continue to deteriorate, the likelihood of wage and price controls further threatens the solvency of an already fragile corporate sector. Given this environment, it is not surprising that insolvency is a growth industry. The demand for professional services from corporate lawyers, receivers, and trustees in bankruptcy is likely to increase. Lawyers in general practice are likely to feel the effects too, as increasing numbers of corporate clients seek professional help. I hope that the talk I'm about to give will do 2 things. First, I want to persuade you that the receiver has more in common with a doctor in an emergency ward than with the undertaker. The receiver does not merely bury the body, nor does he rob the grave, despite some recent newspaper headlines to the contrary. There are almost always harmful consequences when a business fails. However, the receiver has to deal with a lot of angry or anxious people. He seeks to minimize the harm done and to unravel the complex commercial tangle in accordance with well-established legal and commercial principles. My second objective today is to try and provide you with a useful overview of receivership practice. In last year's lecture, Ron Robertson noted that a privately appointed receiver is a many-faceted creature. The subject of receivership is, of course, immense and continuously evolving. While my paper addresses 5 facets, my talk today will be limited to 3 facets. First, I will discuss the informal engagements undertaken on behalf of secured lenders. Then I will talk about the various types of formal receivership encountered in the commercial context. And finally, I will examine the functions and responsibilities of a receiver. The form of receivership I intend to discuss is limited to a receivership of a commercial enterprise in financial difficulty. It has been said many times by way of definition that a receiver is one who receives. The receiver's main task is to convert secured assets into cash to repay or reduce outstanding loans. In addition, the receiver may have the power to manage the assets and undertaking affected by his appointment, whether he is appointed by the court or privately. I will refer to the receiver and manager throughout as the receiver, since the terms have become interchangeable in recent times. In some countries, the approach to receivership is highly legalistic. In contrast, in Canada, legislative and judicial framework within which receiverships operate has been strongly influenced by the business environment and the businessman's common sense. As a result, it is a system worth defending. Before I talk about what he does, you might reasonably ask me, who is the receiver? In the United States, the person who usually becomes involved as trustee is a lawyer, and he, in turn, retains a public accountant for such assistance as is needed. In Canada, however, public accountants play the primary role in insolvency situations, while lawyers tend to play the supporting role. Most receiverships are now conducted by corporations, which are affiliates of public accounting partnerships. Individual accountants may, of course, be appointed as receivers, but this is becoming rare in the case of a large commercial receivership. The corporate approach permits a continuity of authority and name, which is not possible if engagements are taken on in the name of individual partners. Thus, in a large engagement, senior representatives of the receiver can act in several different geographic locations at the same time. The senior insolvency practitioner is a chartered accountant and a partner in a public accounting practice. Those who become partners in a recognized national firm normally achieve partnership after about 10 years of practical experience. Consequently, the public accountant who acts as a receiver has gained considerable practical experience. A receiver brings to his work not only his knowledge of accounting, but the business common sense derived from that practical experience. He also has a fairly wide knowledge of the law as it affects receivership and bankruptcy. Receivers undertake both informal and formal engagements. The 2 main types of informal or pre-receivership engagements are assessment reviews and monitoring financial performance. I will deal with assessment reviews first. When loans are classified as problem situations, lenders tend to call for an outside second opinion on the viability of the loan. Frequently, the second opinion is in the form of an assessment review performed by individuals from the receivership department and by other specialists of a recognized accounting firm. Assessment reviews of problematic loan situations are sometimes called Looksees. They are essentially a businessman's overview of the operations and history of the debtor corporation, its short and medium-term prospects, its current financial position, the current value of the security lodged in support of the lender's position, and the ability of management and management's plans to rectify the current financial problem. Looksees are usually carried out quickly in an atmosphere that is often fraught with urgency. The lender may have become concerned for any number of reasons. For example, the debtor may have delivered a financial statement showing large operating losses, or the loan margins, operating results, or security values may reflect a continuing deterioration. In many cases, particularly these days, the principals of the debtor corporation, in their capacity as guarantors, inform the lender that they're worried about the continued survival of the enterprise. The first thing the lender does is to arrange a meeting with the principals of the debtor corporation. If the debtor does not respond satisfactorily to the lender's concerns, the lender seeks the debtor's consent to an assessment review. Debtors sometimes object to this, but they usually come around in the end. In some cases, the terms of the loan agreement or security document entitle the lender in any event to send in agents to examine the records of the debtor corporation. The terms of the appointment letter are agreed upon by the lender and the person performing the review. The letter is usually addressed to the lender and the person performing the review, and it is signed by the debtor. The letter must make it absolutely clear that the reviewer's primary obligation is to the lender, not to the debtor. Otherwise, there is indeed a conflict of interest. The assessment is not an audit, and the report issued at the end of the review should say that. The reviewer should, however, satisfy himself that he is being given reasonably accurate information so that he can provide sound advice to the lender. What happens during that assessment review? The reviewer examines the history of the company and the industry within which it operates. He takes a close look at the major causes of the debtor's financial difficulties and management's efforts to redeem the situation. He considers whether management is capable of operating effectively in a turnaround environment. The assets are valued on a worst case, that is liquidation, and on a best case, that is going concern basis, to try to determine the degree of risk that the lender will face if the loan has to be called. If the debtor's prospects look hopeless, and therefore reorganization is futile, the reviewer attempts to document the likely difficulties in liquidating the company and ways of minimizing those difficulties. If, however, it seems likely that the debtor's affairs can be reorganized, the reviewer explores the prospects of the reorganized entity from the lender's point of view. The reviewer then records his findings, recommendations, and conclusions in a draft report addressed to the lender. This draft should be thoroughly reviewed with the debtor's representatives. If the debtor and the lender can agree on the recommended course of action, then the first major hurdle on the difficult and complex road to a corporate reorganization can be accomplished. The other major kind of informal engagement that receivers conduct is the monitoring of financial performance. The lender may choose to take the middle road between actually calling the loan and normalizing the lending relationship. In this case, he appoints an agent to monitor the financial performance of the troubled debtor corporation. Its management thus gains time to try to turn the company around. Again, a preliminary meeting between the debtor, creditor, and monitor is held before the monitor goes in. Once again, the engagement letter must make it clear to the debtor that the monitor is the agent of the lender. In turn, the lender must be made aware of the limitations in the scope of the monitoring arrangement. There is no guarantee that the values of the collateral pledged in support of the loan will not deteriorate, especially in the case of an uncooperative or unscrupulous debtor. Perhaps unscrupulous is too harsh a word, but people in financial difficulty do not always act as they do in normal circumstances. I remember a few years ago, I became involved with a business owned by a gentleman who recently came to this country. Immediately upon arrival, he started up a fairly major endeavor and sunk his total worth, which was considerable, and painstakingly accumulated somewhere else into a new venture, which soon became in financial difficulty. Having concluded a fairly positive viability analysis, all concerned, including the principal and his banker, agreed that a short-term receivership was the best vehicle to use in an effort to turn the situation around. On a Friday, I was appointed receiver on consent. Bright and early Monday morning, when my staff arrived at the factory, the place was bare. The monitor watches the financial performance of the debtor corporation, determines that production is not being disrupted, examines the performance of the loan, and reviews the fluctuations in the values of the various assets pledged in support of the loan. The monitor also attempts to measure and reports on the success and progress made in management's reorganization and rectification plan. Under no circumstances should the monitor become involved in management or be an active participant in management decisions. If he does, he jeopardizes his professional relationship with his client, the lender, and exposes the lender to criticism and perhaps legal action if the company is later declared bankrupt. The monitor must also steer clear of anything to do with the purchasing of goods or services on credit for the same reasons. Besides gathering information, the monitor develops his plans and strategies in case management's rescue efforts fail and the lender appoints a receiver. I will now discuss three kinds of formal receivership engagement. They are court appointments under the Judicature Act, private appointments by letter or instrument, and interim appointments under the Bankruptcy Act. Section 19(1) of the Judicature Act, Ontario, empowers the court to appoint a receiver by an interlocutory order in all cases in which it appears to the court to be just or convenient to do so. Such an order may be either unconditional or subject to certain terms and conditions. Because the court-appointed receiver is a creature of the order which appointed him, the prospective receiver does expect to be consulted by the applicant's solicitor prior to the finalization of the draft order accompanying the notice of motion. Most court receiverships arise by way of an application by a plaintiff creditor. In the vast majority of cases, the plaintiff is a secured creditor in the form of a chartered bank. The order sought usually gives the receiver control over both the business assets charged by the plaintiff's security and over those security interests that rank junior to it. The debtor corporation can also seek the appointment of a receiver. However, this is rare. The court-appointed receiver is an officer of the court. He must therefore protect the interests of all the creditors and, of course, the debtor corporation itself. Although he has no contractual obligations to a specific creditor, it has become normal practice for the receiver to ensure that the major creditors are kept informed. A receiver appointed by the court has his powers conferred upon him by the appointing order. The order usually appoints the receiver, in addition, as manager of the assets and undertaking of the debtor corporation. Powers include the power to take possession and the power to institute legal proceedings for the purpose of protecting those assets. The receiver is also usually empowered to carry on the debtor's business, the primary facet of the manager function, to sell, lease, or mortgage the assets, a power subject to court approval, and to settle, compromise any debts owing to the debtor corporation. When is a court appointment advisable? Most receivers recommend that the court-appointed route be followed only in special circumstances. I would guess that less than 1 in 20 or 30 receiverships in Ontario are court-approved. Seeking a court order is the preferable route in certain particular circumstances. In large, complex matters, where the assets and operations are located in a number of provincial or foreign jurisdictions, the Ontario court appointment carries much more weight than does the letter appointment. The court appointment is also advisable when there are many competing security interests. In cases where there are a large number of rented premises, such as a retail chain, and there are many different landlords and utilities to be contended with by the receiver. A properly drafted order functions as an ex parte injunction against landlords, utilities, lessors, and others. The insolvency of a public company or a company subject to regulatory authority is best dealt with by a court order, and so is the insolvency of a debtor whose operations involve hazardous products. A court appointment is also useful in situations where a reorganization is likely, but the nature and timing of the reorganization is uncertain. The second type of receivership appointment, and by far the most common in Ontario, is the private appointment. The powers of a receiver appointed by an instrument in writing, usually a letter, are contained in the security instrument or loan agreement held by the secured creditor. In the typical floating charge debenture we see today, these powers are broad and all-encompassing. Before accepting a letter or a private appointment, the receiver should make sure that the debtor has received adequate notice that the loan is to be called and that a receiver is to be appointed. Otherwise, he and the secured creditor may be exposed to lengthy and perhaps costly litigation. Exactly what constitutes adequate or reasonable notice is a matter for legal interpretation. I understand, however, that the Lister and Dunlop decision of the Supreme Court of Canada is imminent. This decision should clear up many of the present uncertainties. Although many institutional lenders are loath to provide indemnities to their privately appointed receiver, I understand that there is substantial support for the view that there is an implied indemnity, whether or not it is stated in writing. This is not so in the case of the court-appointed receiver. Why is it that most receiverships in Ontario are private? Chiefly because most receiverships involve small business. The additional costs associated with court appointments are an undue burden. Also, the secured creditor does not lose control of the realization process. And finally, the private appointment avoids the invariable delays of the court process. The final category of receivership appointment that I shall discuss is that of the interim receiver appointed under the Bankruptcy Act. He is an impartial person appointed by the court whose role should not be confused with the role of a receiver and manager. An interim receiver can be appointed under two separate circumstances, both with a view to protecting the ordinary creditors. Firstly, he can be appointed to act between the filing of a petition and its hearing. In order for the court to appoint an interim receiver, the petitioning creditor must allege by way of affidavit, and the court must be satisfied, that the assets are in jeopardy and that an interim receiver must therefore be appointed to protect the estate. These appointments are usually of short duration. The court order instructs the interim receiver to take possession of the assets and to control the receipts and disbursements of the debtor. He may not otherwise interfere with the day-to-day business of the debtor. His job is to be the watchdog or custodian of the assets during the 8 days or more between the filing of the petition and its hearing. He has to tread warily, as he may be subject to claims of improper conduct by the debtor if he does, in fact, interfere with the debtor's business. The second circumstance in which an interim receiver can be appointed is upon the filing of a proposal under Part 3 of the Bankruptcy Act. A proposal is a formal plan of compromise which is binding on all unsecured creditors when passed by a majority of these creditors holding 75% of the value of claims and when approved by the court. The interim receiver's appointment is usually a specific term of the formal proposal itself, and the powers of an interim receiver under a proposal can be much broader than those given to an interim receiver in a petition situation. If there is the slightest chance that the creditors will react negatively to the absence of an interim receiver in proposal proceedings, then the draftsman of the proposal would be wise to provide for such an appointment in the proposal document itself. The power granted to the interim receiver in the appointment order should be broad enough to reassure the reasonable creditor, but on the other hand, not so sweeping as to unduly restrict the debtor's day-to-day operations. Moving back to the court or letter appointment, having been formally appointed, what does the receiver do? His first act upon appointment is to protect the assets and exercise such control over the operation of the business as circumstances warrant. If management is honest and competent and normal internal controls are present within the business entity, the extent of the receiver's control over the detailed day-to-day operation tends to be minimal. The receiver then concentrates his efforts on controlling major policy decisions, on sales or purchases outside day-to-day operations, and on providing leadership in formulating the reorganization or the refinancing of the business. In practice, however, there is almost always some form of management deficiency. Otherwise, the debtor would have not failed in the first place. Thus, in most receiverships, the receiver must supplement existing management, even in day-to-day operations. The most important decision for receivers, and often the most difficult in any insolvency situation, is to determine whether to keep the operation going with a view to reorganization, to wind it down with a view to liquidation, or to suspend it immediately and start liquidating. This basic decision should be made before the formal receivership appointment, but that is not always possible. To enter into a major receivership without careful pre-planning is foolhardy, in my opinion. Let us assume that a viability analysis has been undertaken. Operating plans have been formulated. Financing for the ongoing operations has been prearranged. The effectiveness of ongoing management has been assessed and supplemented if necessary. The basic ingredients of a plan of reorganization have been formulated, and management wants it to work. If all these matters have been taken care of, a financial reorganization should have a reasonable chance of keeping the business alive. Financially troubled enterprises which do emerge from a receivership and continue in business usually do so after some form of formal compromise of the debt holders' and shareholders' positions. The receivership is used to rationalize the enterprise by trimming the unprofitable elements of the business. Although the receiver on his own can manage and affect the changes to the operations of the debtor, he has no legal right to institute the formal reorganization plan. This requires the approval and action of the directors. As long as the receiver is satisfied that a formal reorganization is feasible and will not harm the interests of those whom he represents, the receiver will actively assist the directors in bringing forward the formal plan of reorganization. In practice, it is usually the receiver who is the moving force in formulating the plan. The simplest such plan is that in which a third party takes over all or part of the shareholdings and assumes all of the obligations of the corporation. More commonly, reorganization involves the directors approving the filing of a proposal under Part 3 of the Bankruptcy Act. A more complicated form of financial reorganization plan can entail simultaneous offers of compromise to the unsecured creditors under a proposal, to the holders of a debt instrument covered by a trust indenture under the Company's Creditors Arrangement Act, and to the shareholders under the provisions of the appropriate Canada or Provincial Business Corporations Act. These plans consume much legal and receivership time. They're also very expensive. It is essential that the plan be fair to each class, for if any one class of creditors fails to approve the plan, the overall scheme of reorganization is likely to fail. Successful financial reorganizations are, unfortunately, less common than liquidations. In many cases, financial reorganization is not a viable alternative for all the reasons which led to the formal failure in the first place. On the other hand, a receiver seldom decides to close down the operation immediately and to make no attempt to maintain even the semblance of an operation. Usually the receiver continues operations, if so doing will increase the amount of cash available to repay or reduce outstanding loans. Some component of the business may be healthy and therefore capable of being sold as a going concern. Inventories may have considerable value if they're completed, whereas semi-complete inventory may have little or no value. Outstanding contracts may require completion. In order to maximize the realization of accounts receivable, operations may have to continue to the extent necessary to honor warranty obligations. Any of these circumstances may be sufficient reason to keep the operation alive, if only temporarily. For the receiver to maintain even a semblance of a going concern operation, the ingredients necessary for the operation of any business must be present. The receiver must determine that adequate management and supervisory staff are available and committed to remain during the operating period. He meets with employee and union representatives and agrees on the employee relationships to be in force. Productivity invariably declines during a short-term receivership operation. This problem can sometimes be overcome by reaching an understanding with the union, perhaps involving special bonus incentives based upon agreed productivity and completion targets. The receiver often encounters problems in the supply of raw material. Suppliers occasionally refuse to supply even on a COD basis unless their past due trade account is paid in full. Customers of the debtor in receivership may cancel their back orders or seek special price reductions. And product warranties create a special problem for the receiver. The most common solution to the warranty problem is to negotiate a reduced warranty with the purchasers of the products or to contract out the debtor's warranty obligations to an acceptable third party. Arranging short-term financing for the receiver's operation is seldom a major difficulty. Payment of normal trade terms on accounts outstanding at the date of the receiver's appointment is usually suspended, thus creating a short-term positive cash flow. The court-appointed receiver borrows new funds by pledging of assets by way of receiver's certificate. In smaller private appointments, the debenture holder provides direct short-term financing to his receiver without going through the formalities of issuing receiver certificates. I have attempted to enumerate some of the substantial risks in continuing operations in a receivership. The creditors are entitled to be repaid as much of the money owed to them as possible. The receiver should be prudently conservative. He is not a venture capitalist with creditors' money. I do not believe it is the function of a receiver to maintain an operation if the downside risks of doing so unduly jeopardize the position of those who have a real interest in the proceeds from the anticipated realization. Having talked about some of the things that receivers do, I'd like to briefly discuss the receiver's responsibilities. The responsibilities of a court-appointed receiver are clear and unequivocal. The receiver, as an officer of the court, is responsible to the court. He is neither the agent of the debtor nor the agent of the plaintiff secured creditor. He is not, however, the agent of the court. The court is not liable for his debts. The court-appointed receiver is an impartial person acting in the interests of all affected parties. The privately appointed receiver must ensure that he does not exceed his powers as contained in the security instrument. He seeks direction from and the consent of his client, the debenture holder, for all major decisions. In this respect, his responsibility diverges from that of the court-appointed receiver. However, even though the private receiver is not legally obliged to be fair and impartial, most financial institutions and the receivers acting for them take great pains to protect the interests of other creditors, particularly when the value of pledged assets is in excess of the amount due under the debenture. By keeping junior ranking creditors informed and keeping their interests in mind, the receiver can forestall problems. There has been some controversy recently over whether the private receiver is an agent of the debtor company or of the debenture holder. Somebody not trained in the law, I find it difficult to understand why there is any doubt as to who is the principal of the private receiver. The debenture holder chooses the receiver, he appoints him, has the power to remove him, approves of his actions, receives his reports, and remunerates him. How can the receiver be deemed the agent of the debtor company? I gather that it is the accepted legal view that the private receiver is the agent of the company with respect to some matters and the agent of the debenture holder for others. This whole subject is complicated and topical and therefore probably worthy of a separate paper on the subject. I believe that the private receiver's first responsibility is to the client, the debenture holder who appointed him. If it is advantageous to the realization process to act as agent for the debtor in connection with certain transactions, the receiver should do so. As is set out in the Canada Business Corporations Act, Part 8, it is the duty of the receiver to act honestly, in good faith, and in a commercially reasonable manner. By keeping the creditors at large and the principals of the debtor company informed and involved, whether he is legally obliged to do so or not, the receiver minimizes the possibility of adverse actions, and I believe he therefore has a professional duty to do so. However, the receiver should not take unreasonable risks with the interests of the creditors in his attempts to preserve goodwill and to rehabilitate the corporate entity. In my address, I have tried to provide a highly condensed account of the chief aspects of receivership. My paper is somewhat more detailed. Attempting to describe the realities of receivership practice is like shooting at a moving target. The practice continues to evolve, and at an accelerating rate. 20 years ago, the major corporate failures tended to be the result of fraudulent activity. Clearly, that is no longer the case in our present economic environment. The legislative and judicial framework continues to change. The next few years will see major changes when the long-delayed new Bankruptcy Act is passed by Parliament. In addition, new statutes and regulations are being enacted, partly in response to social pressures to provide wage earners with some protection in insolvencies, and partly because certain government departments are attempting to obtain statutory priority for the claims of their own departments. In addition, more subtle changes will continue to emerge from court decisions. As I pointed out at the beginning of my talk, companies are failing at an increasing rate. Many different factors have contributed to this phenomenon. I believe, however, that the fundamental cause of corporate failure is the inability of management to cope with change. In a business environment in which far-reaching change will be brought about by technological innovation, business failures are likely to continue to increase in number even if our economic climate improves. As lawyers, you are likely to have to advise your clients on insolvency matters increasingly often, whether they be creditors or debtors. I hope that my talk today has provided you with a useful overview of receivership. Thank you.